Well, the Commissioner can't now stay to hear my comments on what he had to say. We're joking apart. We will continue now with the panel immediately, but let me just reflect a little bit what I think I have heard here, where there was a very strong message to all of us on the importance of actually balancing data protection rights together with some other important interest rights, be it health, progress and health data, be it lawful government access to data security and safety. And the Commissioner hasn't said it, but equally children's protection, online safety, competition, these are all important interests that we have to balance as a part of our role as privacy leaders and regulators, because I see some, I think we have to do that more. And that clearly came across very strongly. What also came across very strongly is the importance of data and for digital transformation, right? And GDPR regulates personal data. It is one of the most important and horizontal laws, so we have to make sure we interpret it and implement it in that way so that it works together with the other rights. What I've also heard is the simplification agenda is very strong at the Commission's mind. Yes, they're focusing on SMEs. It looks like for those of you who are SMEs, good for you. But remember, SMEs can also create risks and harms, right? It doesn't matter how small you are. You can be one woman in a garage at the back of my garden, and you can create lots of risks and harms. So, we really need to be mindful not to do these sweeping changes of law which only help SMEs but actually don't help anyone else. So dare I say, records of processing, does it help anybody actually anymore? Even large organizations and not only SMEs. But there we are, clearly a push also for data protection regulators to think about SMEs more. And then finally, I think I have also heard something about thinking about how can we interpret the rules in a new way, in a more progressive, evolving way. And I think it's something that I personally also believe is the key. We can't always change the rules, but we could have the courage as privacy officers, as privacy lawyers, and importantly, most importantly, privacy regulators. We can have the courage to interpret the rules in a more progressive, broader way. And I think we've seen the DPA starting to do that. And he also, Commissioner also mentioned risk-based approach, right? GDPR was built in a risk-based manner. So it allows us to calibrate compliance based on risk. So maybe this is also the way forward. So with that, I hope you've enjoyed that very brief session with him, heard about some things that I thought I heard as well. He hasn't mentioned data flows, but he has mentioned GDPR procedural rules that he's also working on. And with this, can I now ask my panelists for the panel that I'm going to be moderating to come and join me on the stage. And this is going to be about the most important topic du jour, which is AI and data protection. So please come forward. And I shall find a seat somewhere in the middle, hopefully. The light is so terrible here. I need to put my glasses. I can hardly see anything. There we are. Okay. Okay, so again, my name is Bojana Bellamy. I lead Center for Information Policy Leadership. We are global privacy and data policy think and do tank out of Washington, London, and Brussels. Or should I say Brussels, London, and Washington? I think that's a more better way. Our job is solely to enable responsible use of data in this new digital world in a way that protects privacy and other interests as well. We act as a bit of a pressure group, I think, to all companies who are developing accountability and privacy management programs and data management programs, regulators who are overseeing the rules, and legislators and policymakers who are creating the rules for this new world. And I'm really delighted to have a fabulous panel here that is going to keep us awake for an hour plus of really great leaders, politicians, practitioners, and that's what we need to discuss this very topic. And the topic is, how do we align data protection and AI governance compliance? How does data protection work in the world of AI? We've had some interesting developments very recently, and may I suggest, in form of introduction, that perhaps there are 4 ways in which we could look at this. The first would be how, in this post-Draghi moment that we live in, and these are little provocative comments that I know we've discussed. In the post-Draghi moment, where we were told we need to do more on digital transformation, enable better digital single market and data market, maybe cut some of the regulatory tape, right? How do we look at data protection and GDPR as an enabler of European AI competitiveness, as an enabler of us doing more in the AI space, right? What does that look like? And maybe there's some tensions between how the rules of data protection work and how the technologies of AI are applied. Shall I just mention legal basis, right? A use of sensitive data, we'll talk about this, but even purpose limitation retention or the rights of individuals. How do we do this in the world of AI? And so how do we resolve these tensions? Are there some legal lacunas that we maybe need to plug as well? You are dealing with this every day, from automated decision making, the small machine learning, to big generative AI and general AI and agentic AI that's coming our way as well. So that's first perhaps a prism under which we can look, and we will talk about that. So GDPR, not a barrier. How can it be an enabler? Secondly, what is the interaction between the AI Act and GDPR, right? Particularly those practitioners amongst us, how are you thinking about this? Can we leverage data protection compliance also for AI compliance so that we do not overburden our companies? What have we learned that we can actually apply? But there are also some, perhaps, in that intersection, some complexities, transparencies in both laws, but what does it really mean, right? And then maybe thirdly, regulatory oversight. What does that look like, right? In this world of data protection and AI, where we may have platitude of regulators who are all going to be interpreting one law, and you've heard the Commissioner, consistency is absolutely essential, right? So how do we do that in a way that also enables engagement, constructive engagement, in a way that is risk-based, in a way that also is smart, and takes account into innovative regulatory approaches like sandboxes, etc. So I think these are the 3 prisms under which we can look at this whole topic. So with that, I'm going to be actually asking our panelists, I'll introduce them very briefly, to actually kick us off. And Michael McNamara, you are the member of European Parliament, have been incredibly vocal on a number of issues in your membership of LIBE committee, but also AI working group. I'd like to start with you. Tell us a little bit, how do you see this relationship between data protection and AI in the post-Draghi world? What do you hear from your constituencies?
Well, obviously, up to now, I suppose, data protection, GDPR, and people working on that, and people working in AI have always worked in silos. Clearly, that's going to have to change as we move a lot closer to implementing the AI Act. You asked, I suppose, how GDPR can be a facilitator, and I suppose there are very few that would have an obvious answer to how it could be a facilitator. I mean, it's, I think, not really seen as a facilitator across Europe, not just by big tech companies that for whom data is their raison d'etre, or their main commercial activity, but for companies and commercial activity enterprises where data is not, processing data is not. Neither is it seen as an implementer, but I suppose the advantage that it does have is that I think people in Europe, as a result of it, and there's been a lot of pain, but as a result of it, people do have a degree of confidence that that their data privacy rights are being respected, that there is somebody, there is a regulator making sure that their data is not being overly used and is not being abused in the commercial space. And I think that is important as we try to drive the use of AI in Europe, because we know that and as Draghi highlighted, the use of the uptake in AI by private citizens, but also in industries, and the two are inextricably linked, of course, is much lower in Europe than it is in some of our competitors. And if we are to view the United States as one of our main competitors, it's lower in the United States than it is in China. So we have a very different approach to data privacy, to GDPR, obviously, in Europe than the United States, much less in China. But I think we have to see if we can use that to our advantage in creating a confidence among our populations that they are being protected.
Thank you. And really follow-up question to that, Michael. Parliament obviously has had a huge role, core regulatory role in creating the AI Act and GDPR. But what is the role of Parliament and parliamentarians like yourself now in sort of making sure that we implement this in a correct way, that we get the spirit right and don't overburden? What can you do practically, maybe?
Well, I suppose practically what we can do, what we are doing, is there's an AI implementation working group. I suppose unfortunately it sits in Camera. So we had a very long and quite interesting, I suppose, which is a very euphemism for fraught, perhaps, meeting yesterday regarding the third draft of the code. There was an article in the Financial Times about it. There's a concern that among many, it must be said, who were involved in the legislation of the AI Act in Parliament, that where the code is heading isn't necessarily where they had envisaged it would go. I wasn't among them. I was a member of the Irish Parliament before last June. It's my first term in the European Parliament. I am a co-chair of that group. So I suppose what that is who is it's essentially holding the Commission to account, the AI Office and the Commission to account on how they're implementing the Act. We've had the chairs and the vice chairs of the various working groups that are bringing forward the draft code. We've had them in on several occasions to discuss each of their drafts. Hope to have them in again. That is, I suppose, what can be done. It's also to express, with regard to the draft, not just the draft code, but guidelines that have come out on prohibited practices, and the guidelines are anticipated to highlight what we're hearing from citizens, but also from commercial interests across the Union about the applicability of what is coming out of the AI Office.
And thank you always for that engagement. I think it's highly appreciated, the transparency and openness with which yourself but a number of other MEPs are also ready to tackle some of these things. Let me now move on to Jordanka Ivanova, who is at the EU AI Office, the famous new AI Office, right? We all would love to see what it looks like inside, or outside as well. But Jordanka, tell us a little bit, in way of your introductory remarks, what is the Commission doing at the moment now? What's sort of in the implementation process of the EU AI Act, right? We've had the code of conduct being developed. What are you spending most time on? And how do you look at this now, given the Draghi sentiment of simplification as well?
Thank you very much for having me here, indeed, of one of the representatives of the AI Office and one of the people involved in also this negotiation process up to now. So yes, we have so much work to actually prepare, support the implementation of the AI Act on so many fronts, preparing all the guidelines, all the code of conduct, providing all the legal certainty, support also for companies to prepare with all the different staged approach of the rules that apply in different cases, and do a lot of outreach, consultation, and actual involvement of all relevant stakeholders, because this is very important also for us in this implementation process. And then a lot of efforts, of course, also to coordinate this process, prepare with member states the future supervision, especially the system level rules that will apply at national level, with all the different regulatory bodies we have, with the AI board now being established, with a lot of subgroups, and helping member states and their authorities in this designation process, and further preparing the capacity, ensuring that everyone is also coordinating and preparing in the future implementation because it's very important for us to have this consistent understanding and effective implementation, and a bit demystifying what the different rules of the AI Act mean, and also very importantly to bring into the objectives of the AI Act, that is enabling the safe innovation and development of these technologies, bringing the trust needed, because it's been since the very beginning of the AI Act's approach very targeted, risk-based, and all these efforts we have both with regulators but also companies in different initiatives. We also have like the AI Pact, including thousands of stakeholders, AI webinars, and all the relevant guidelines, and the code of practice that was also mentioned, but also many that are coming, including for the high-risk rules, the transparency requirements, and also very important objective in all our efforts are indeed to ensure clear, lean implementation, reducing any unnecessary burden or unclarities, also in the way this act should be implemented consistently across all different member states, but also by companies. So that's why we are both working with the member states, but also launching AI help service desks in the future, preparing the numerous guidelines and codes, and also developing further initiatives like the sandboxes, further working also now on clarifying the interplay between the AI Act and other rules, including for the GDPR. We are also obliged to produce a number of guidelines, including for this aspect. So it is very high on our agenda, and we in our coordinations want also a lot to engage with all relevant stakeholders and bodies that are responsible, and that's why we vote for the product safety approach, because it's very clear also to understand the different approaches of the Act being a product safety legislation, the various frameworks that it employs compared to other acts that are more like GDPR technology neutral, and they have different scopes and objectives. So. And also, of course, to work together so we can ensure that everyone has a clear understanding of these rules, including with the preparation of the guidelines, but also at the future enforcement level, once the Act becomes fully applicable, because we have to ensure there are very clear procedures for cooperation between the various authorities, and we already have a number of those already integrated into the AI Act itself, with various other fundamental rights authorities or others that could also interact with our market surveillance authorities, exchange information. So we have a very clear and smooth implementation of all acts, while also avoiding overlaps and bringing and helping companies to develop these tools for the benefit in the European Union, our consumers, but also companies and our competitiveness.
Jordan, sorry, I keep forgetting I need this. Jordan, just a follow-up. I remember in the discussions on the AI Act, it was mentioned by the Commission, you might also remember this, Michael, that the Commission expects just about 10% of businesses to be actually covered by the AI rules. Is that still the expectation, given the risk-based approach and prohibited processing, high-risk processing, and who is covered and who is not? Is that still the interpretation?
Yes, I would say it's very much still in relation to the high-risk requirements, which are maybe the most important for companies to go through this conformity assessment process, because this is the main focus of the Act, right? It's for other systems that are not high risk, we would actually not impose additional requirements, only limited transparency obligations for chatbots or AI-generated content in certain cases, and yes, the prohibitions, which are more in a way really clarifying or setting a limited set of very harmful and unacceptable practices, while there we've also tried to make a very clear link with what existing legislation, the interaction could play. In terms of yes, impact, it is still very much our estimations that there are a limited number of about 15% of companies. We also have a risk filter, which will be also clarifying for providers who think that they could be potentially followed under the high-risk category. There are certain conditions under which they could self-assess themselves. And we are preparing guidelines and we'll be launching through a consultation process for this. So we are very much looking forward also to input from companies to get the practical cases, examples, so we can really help and clarify the scope of the high-risk category, which is the most important one.
And I think it really is important to clarify that. I mean, I do want to say also that if you think 10 or 15% of companies are impacted, you probably all will be here, because everybody today is using AI in employment, HR decisions very often. Not completely solely, but very often, and that's in the risk in the list of high risks as well. But no, truly, it was really welcome. It was good to see the work you've done on implementation, but particularly the digital literacy guidance and the one on the scope as well. And we look forward to the one on intersection with GDPR and other rules. And I mean, we at CIPL are working on this a lot, and many others, so we do want to engage with you, please. And let me now move on to Juraj Čorba. Juraj is co-chair of the Global Partnership on AI and also acting chair of the OECD Working Party on governance of AI. And so let's take this a little bit conversation outside of the European and Brussels bubble. What are you seeing, Juraj, through your work in terms of the discussions and debates at the OECD member states, but also Global Partnership on AI? Is the world moving in the same direction where the EU is going, or perhaps slightly different? And I have some follow-ups, but let's start there.
Yes, thank you very much. First of all, thank you very much for having me. This is my first time with Forum Europe. I myself am here not necessarily to represent the views of the Global Partnership on AI or the OECD. As you may know, these clubs are really extremely big. Even the Global Partnership on AI itself, which was embedded into the OECD last summer, covers now almost 40% of the global population and even a higher share of economic output globally. So all my thoughts today will be my personal thoughts. I'm having the role of an honest broker in these groups, so I try to bring people together to a consensus on important issues related to AI governance globally. Now, with respect to your question, yes, it is a great honor to be able to see the world or a major part of the world in one room discussing issues related to the relationship between privacy and AI. What is really surprising to me is that we tend to think in Europe that privacy is not necessarily being addressed maybe as carefully as in Europe in some of the other parts of the world. My impression is that this is not necessarily the case. Although, of course, many countries around the world take a different approach to privacy. Even the cultural notions of privacy tends to differ, and this is extremely interesting to see. What is also interesting to see, of course, is that there might be differences across generations. In other words, the habits that young people have might be different from what we have as a settled norm or a value that we care about or not. So there might be even some developments when it comes to the values, especially among young people and how they see themselves on the topic of privacy. That's very interesting to see. For the European Union, as we are now here in Brussels, I would say, let me give you a metaphor. When I was at the high school and at the elementary school, we used to play football during the gym. And I remember one of the key recommendations from our teacher was that when you play football, you should never just watch the ball below your feet. You just cannot keep watching the ball, because you need to look around where to pass the ball, what is happening on the playground. Only then you can actually play the game. if you look around and you keep your head up. I think what is very important for the European Union these days is to keep our heads up and to monitor and watch closely what is happening around us, given our dependency on technologies from the outside world, how our rules and expectations and requirements interact in real time with requirements and expectations in the other corners of the world, and what it means to us. I think this is absolutely crucial these days.
Thank you for that. First of all, I like the football analogy. I think it really is important. It is all about looking ahead, and I think part of actually being smart about the AI is to look ahead how the technology is developing and how it's going to sit with our rules as well. I think that's also something that we all need to do more of, I feel. And I've seen the privacy regulators also much more engaging with where technology is, but the geopolitics of it as well. And you mentioned about data protection and AI. This is not just a European phenomenon, indeed. And we've seen, Brazil thinking about regulating AI. Also, a number of countries, US states, are passing state laws on privacy, but also AI, right? Or trying to. We've seen Korea, Japan, Australia. They all have data protection laws, but they're now doing the same as we are doing, is how do we enable these data protection laws to work with AI so that they're enabler as opposed to barrier. But can you also, Juraj, tell us about this shift that I am sensing, and maybe others can comment on this as well. There was a lot of discussion on all of these summits, global summits about AI safety and AI risks, but I think that the mood is different now, not just in Europe, but globally, and that is how do we enable opportunities of AI, and how do we enable adoption of AI for competitiveness, for progress, for efficient governance, for health, for all the reasons. Did you notice that in Paris? You were the AI Action Summit now, and what does it mean, this change of, is this just a change of terminology, or is there really deeper change?
Well, it's a good question. It's clear that the French, together with India, because India was actually a co-host of the French AI Action Summit, they really tried to refocus the attention of the summit series that have started in Bletchley Park in the UK some time ago, to refocus the topic and the attention from safety to the opportunities. Now, of course, this has also met with some criticism that certain people felt that safety is not yet readily solved, and we should not be just discussing the opportunities, but we should keep also the safety and security aspects in mind and work on them collectively across the globe to the extent possible. So yes, there is certainly a tendency to try to motivate people to explore, maybe even to be more playful, because that's where the innovation comes from. You play around with things and then you see, right? There was also a tendency at the Paris AI Action Summit to stress the openness of the available solutions. I guess that's the, among others, French emphasis on the possibilities or opportunities there with the open source solutions. So yes, there is a shift, but I wouldn't say that the safety aspects have been successfully addressed these days. If you look at the, I guess now the most comprehensive report on the safety of AI, published by Yoshua Bengio and his team, which was commissioned by the UK government, there is a clear message that currently, for the most advanced systems, the technical solutions are not readily available. What that means? That means that we need more responsibility from people, from individuals, from CEOs, from all people in responsible positions, including the government. And we can discuss what this means for privacy.
Excellent. I do believe that corporate responsibility still matters in this new world, post-Draghi, post-Trump, or whatever, deregulation as well. I was at the OECD event. It was organized with CNIL and Korean Data Protection Commissioner, and it was incredibly rich conversation where I certainly heard that shift taking place. There was a lot of discussion about how do we think about risks, but also benefits, and risk, loss of opportunity of not doing AI correctly, not regulating correctly. And I will talk about this in the conversation, but you mentioned open source, so let's move now to Nicolas de Bourvil, who is from privacy policy moving so much into AI, but also relationship between the two. And Nicolas, of course, you work for Meta, that has been a huge proponent of open source frontier foundation models. Tell us about AI at Meta and where it is going, and maybe some reflections on sort of how you are seeing now your company being positioned in this post-Draghi moment.
Thank you so much for the invitation. All right, so maybe I can start with the fact that it's maybe not really perceived this way, but obviously Meta is really an AI-driven company. Everything that we are doing since many years, actually not only until like the last few years, is embedded with AI. And this has been useful for us to deliver the service that we deliver on our platform. And now, of course, things are changing, because not only is it how we deliver our services, it's also that we are building AI products and AI models. And so AI for us is really like important in everything that we are doing. So obviously, like in the EU, the regulatory framework I would say is very complex, and that it's bringing a number of like difficulties for companies. We had some difficulties to launch some of our AI solutions in the EU. We actually just started last week to launch Meta AI in the EU. It has taken a little bit of time. We would have hoped to do that earlier, but now that we are on the market, we can focus on like delivering good experiences to people. So that's one aspect of things, but we are also not only a developer of AI systems, we are also training models. And as you mentioned, Brianna, the approach that we have taken is to focus on open source, because we do believe that this is a great way to actually provide all the value of AI to the greater public in Europe as well. And so we truly believe that with open source you can provide the best value to industry, to think about like health research, think about agriculture, education, employment. There are so many different aspects where AI is going to be transformative. One key element, I think, for us is to understand that with the AI Act, not only there was this idea of an ecosystem of trust, which is absolutely essential, and I think that in the EU we have many regulations that tend to go in that direction, but there was also the idea of the ecosystem of excellence. And so for us, what's very important is to make sure that the way we interpret existing regulation, and I'm thinking, for example, about GDPR, it needs to be made in a way that is consistent with the ambition of the EU to be, top of the class in terms of like AI development. And I think that this is a little bit what the Draghi report is also pointing to. The fact that there is a real risk that Europe is going to lag behind when it comes to AI development. And so this consistency of interpretation of regulation to enable AI innovation, I think, should be at the center of the discussion. Yeah, I think that's basically.
Let me follow up, because I think people deserve to actually hear the full story about what led to the December 24 really good and helpful, I think, opinion of the EDPB, where they opined on a number of areas of how the particular rules of GDPR apply to generative AI, including legal basis and personal data. So this started with Meta, right? So do you want to tell us that story? Explain how this happened. What was the question that you had with the Irish, and how did that end up with EDPB? And let them talk about EDPB as well during the questions.
So I think, as everybody knows, when you're training an AI model, you typically have like two different sources of data that you can use for a company like Meta. You've got publicly available data on the internet, and then you have data that you have on your own platform. I think that until May, basically last year, every company on the market training AI models were relying on publicly available data on the internet. You know? And what happened in May, is that we started to announce that we were intending to start using first-party data, publicly available first-party data from accounts of adults, so above 18 years old, to train our models. And doing so on the basis of legitimate interest, with obviously providing people with transparency and the possibility to object, and so that was what we were intending to do. And what happened is that this has created a number of interrogation from data protection authorities, which has led us to actually pause the start of the processing. So when I say pause, the processing never had started. So we just didn't start that processing. So one thing that is important to understand, why is this data relevant? Because I think ultimately it all goes back to that, you know. Training an AI model, for the model to be relevant and to be tailored to the needs of a specific region or tailored to the need of a specific use case, you need data. Training an AI model requires a great amount of data. And the quality of your model will highly depend also on the quality of your data. And so for us, it was essential to have a model that also reflects the specificities of the European region, the cultural specificities, the linguistic specificities, and so that's what we wanted to do. Right. So this led to a number of discussions with the IDPC, with the EDPB, and then over the summer, I think as maybe of us can remember, there was similar discussion in the context of X and the Grok model, which ultimately led the IDPC to request an Article 64 opinion and raising the question of the legal basis. What legal basis can you use to train AI model? And I have to say that it was a long-awaited opinion. It has taken a lot of time, and when you think about when those reflections started with DPAs, it started more than 2 years ago, because we had the ChatGPT task force already addressing those issues, but there was no clarity from the data protection authority. And the consequences for companies developing AI models are potentially very, very high. It's not only a question of fine, it's a question of potentially having to retrain a model. And retraining a model is excessively costly. It has also a number of other implications when it comes to environment and everything. So, you know, the consequences are extremely high, and so clarity is absolutely essential. And I can finish just with one thing. I guess that it was a long-awaited opinion. I think that among the good things, and we are very happy to see that, is number one, the fact that we could see a clear signal from the data protection authorities that innovation is something that they are aiming for as well, and this is very important to have this kind of message. And the second thing is the recognition that legitimate interest is an appropriate legal basis to train AI model, and this is very welcome, and so it's a very positive development.
Yeah, absolutely. And you know, if you think that this is not relevant for you, I think it's important to understand that every company is an AI company today. You may be using third-party provided LLMs, but you're also probably using some of your own data, first-party data, to develop your own product services or to understand insights, to have insights or patterns or predictions. And it is incredibly important that there is this legal clarity about legitimate interest being able to be used both for first-party use, right, and third-party, so taking away data from internet. But of course, subject to balancing tests, subject to necessity, and there are lots of questions there that we as organizations have to fulfill to be able to do that. But I agree with you. I think this was a very helpful opinion. It came at the same time when UK ICO also issued quite progressive, smart, its own opinion as well. Sadly, UK is not in the EU anymore. I think we do miss their leadership also in these topics, but people do read this stuff. And then of course CNIL has been doing for quite a long time these how-to cheat sheets, as I call them, which are super useful as well. So it's it's a culmination of really important work by data protection authorities. But as they also say, there's more to be done, and we'll talk about that as well. Rico, I know you were waiting for a very long time. Now, Executive Vice President of Cybersecurity at MasterCard, a different role that you play. Tell us a little bit about the importance of AI in your role, and how do you see privacy and cybersecurity also interact through AI?
And thanks for having me. So, first to position my role, so I'm the lead of cybersecurity product teams. So I have like a team that does product development, cybersecurity products that we sell beyond banking. So don't think about credit cards, think about solutions that are usable in every industry. AI is for us a foundational technology that we use already for many years. I think like my colleague Nicolas said on that. So AI is crucial in fraud management in cybersecurity because you are looking to a vast amount of data, and you have to figure out the differences between fraud that happens in Dubai is not the same fraud that happens in Europe. Just it's different. So the same model can all apply.
You want to know how.
And you don't have manual ways to put all these rules in. So that is like a crucial element of why we need AI as a base of fighting fraud, fighting crime. So in this role, I have an AI development team in Gothenburg, 250 people. I have an AI development team, R&D team in Dublin. So we have huge amount of teams in Europe that focus on AI development. And what I see them struggling with in the day-to-day practice is if you start with to start from a perspective of taking all the risks that you are trying to need to mitigate to make an AI product work, you don't develop anything anymore. If you look at the opportunity, you can develop things. And I think that is what we learned through the practice is. And I'll give a very concrete example. So we acquired a company called Recorded Futures in December 20. We closed the deal. It's the biggest single line trade intel company in the world. Yeah? And their R&D team in Gothenburg, what they do is they build AI models to collect the data on the internet, but from everywhere. What they do very nicely is indexing it, which is good because I need that. Otherwise, I can't retrace it. So, but they do that very well. But then when we start using these AI models into practice to turn raw data into information that can be used by governments, by corporates, in order to protect them better, in order to know what the next criminal act will be against them, well, then we see that we are limiting what we can do with the data. We are limited in how to collect the data, because there's some limitations there. We are limited in how to use the data, which data we can store. We have to make anonymized, and they say, oh, you should use the synthetic data. Challenge with synthetic data is it only predicts what you want to predict. It's like saying, I want to prove that I can bake a nice cake, and I only put nice cakes there. I don't put failed cakes there. Just that kind of learning. It is a bit a challenge that synthetic data only predicts what I want to see, and in that way, what criminals do is try to make sure that you can't predict what they do. They make it unpredictable. De facto, they go out of the norm. And if they go out of the norm, and a synthetic data set will never detect it. A real data set will detect it. And a real data set will consist of, there are ID data stolen, there are card credentials stolen, there are IP addresses used to do an attack. All privacy data. So privacy is the core of the AI models that you build in fraud and cyber models. And I think we need to really think that through, that together with trying to make AI, so a lot of the AI tools and a lot of the GDPR tools or privacy tools are meant to say, what if someone using information for an end consumer to make the end consumers to use their data and to provide service or marketing service to it. We want to protect against an overload of bad data. But there's also other use cases of AI and in cybersecurity, one of them that are really The other thing that I do want to mention is we stumbled in looking at GDPR. We did a nice twist, and I do want to be proud of MasterCard for doing this. When we looked at GDPR, we saw a weakness in the tooling to help enforce GDPR and to control GDPR. So we launched last month a new tool which is supply chain privacy checks. It checks when you give your information, with your consent to a company, these companies use subcontractors, and the whole supply chain. If you use the whole supply chain, who's checking and responsible? Who's checking that all those data are stored in the right way? And we know that every big company has more than 100,000 suppliers, and every supplier of these suppliers has 1,000 suppliers, so it's a scale business. So there's no manual way to do it. So we built an automatic tool that detects vulnerabilities in your food supply chain on privacy data. We think this is a crucial foundational tooling that was not available, and that will help companies in Europe and everyone in this room and governments around to look at that problem and now have a tool available to help them. So in that way, one of the initial questions was, is GDPR and AI Act do something good? Yes, because now we're developing with the thought in mind, how can we now develop and innovate in that domain to create new tools that are helping corporates, governments to look at the supply chain. And I do mention government because governments are a huge domain of privacy data holding, and they outsource almost everything. I'm exaggerating a little bit, but I do want to make sure, and they have no control on the supply chain. As maybe the first time, the second time, there's no control. So I do want to kind of make two things, just two remarks. Yeah.
Thank you for that, and I think you're making some really interesting points. I mean, one thing that I particularly care about, and I keep hearing this, is that the extent to which R&D is happening, research and development happens in companies, in commercial entities who are, having completely scientific ways of developing products, services. I mean, it's not universities anymore. And so, when we think about GDPR, like how do we enable also exemptions from Article 83 types of exemptions? That's what UK is also doing. And it's interesting you said how you are doing huge R&D with data, but the same is with AI training. It is kind of a form of R&D for scientific research as well. So you have to have a product which actually works. And I think that's something that we could maybe look for potentially clarification, how that works with GDPR. And then the second point you made, Rigo, which was really important, is privacy-preserving technologies. And we are a huge believer in these. And in fact, Sipple has written a paper. We just published something yesterday, right? My team on pets and privacy-preserving technologies in AI, where we're looking at case studies from synthetic data, differential privacy, used in AI. But I'm with you, we're seeing lots of applications, but they're not a panacea. They're not going to be like, we will just do pets and then everything is okay. It doesn't really always work, but they're going to be very useful. So you have to invest in this. You have to understand that as privacy leaders as well. Nicola, I'm sorry, did you want to?
Yeah, I want just to add one thing, because on the R&D front, I do want to mention that if Europe wants to play a bigger role with R&D in innovation and AI, you need to enable in Europe the innovation and the research on this topic. Because at the end, maybe the battle on building foundational AI systems is lost, but the use case, the big value of an AI tool is not the basis, but is a use case application. There's a huge market there, a huge potential for Europe to shine on that one. And you have to think, if our regulations help on these topics, to shine, to have European R&D people, innovation people shine on this one. Do we give them the right support and methodology to really innovate, to use AI use cases? And then think about, so that's what I really ask from a regulatory point of view, think about how you can help research and development in Europe to shine, because they can use the data in a better way. And indexing, to be honest, is a good way, because indexing gives that you are classifying your data, what is the source, and that if something works or doesn't work, you can retrieve it and you change it. So in that way, there are some good things in the AI Act. There are some things that I think are inhibiting us from creating further innovation hubs in Europe around AI use case applications.
Great point. Nicola, did you want to?
Just a very quick reaction on the pets and synthetic data. I think that one of the tensions that when you train a model, your ultimate goal is that you want the model to understand the world around you. And I think you just mentioned it for fraud, but I think that could be true in any kind of situation, whether you're talking about building a chatbot on the basis of the model or building like a, I don't know, like medical app to detect whatever disease. And the difficulty with those technologies is that to some extent, it does reduce the understanding of the model of the real world. And so I'm not saying that it cannot be used in certain contexts, but we need to be careful not to give the impression that this is actually going to be the solution for everything. And also we need to remember that once a model is trained, it does not contain the data that it was used to be trained on, you know, and that's something that we tend to sometimes forget. And I think it's important because from a privacy perspective, it also reduces the privacy risk here.
Okay, can I actually follow up? Jörg, you probably want to say something on this. Can I just follow up on this thing? This is a big debate, right? And you're going to also be answering questions to your general counsel or business leaders. You know, is there personal data in the models? Well, yet, and we hear there are no databases of the kind that we are used to, right? You can't find something of Brianna Bellamy that easily in that LLM, but the outputs, Nicola, the outputs do churn out personal data. And in fact, we've just heard of this unfortunate Norwegian case, right, which is now going to go all the way to the European Court, where the guy was, you know, accused by ChatGPT to have killed his 2 children, which he hasn't. It's hallucination of the worst kind, and it was the old one, right? It was the first reiteration, which now doesn't happen. So how do we? So again, you know, are our rules fit for purpose? Do we care what's in the system, or do we care about the output?
Maybe if I can,
Yes.
a few points, maybe first on the innovation and how to enable the research and development. I want to very much clarify that from the AI Act perspective, we are a market-based legislation, so we clearly kick in only the moment as the system is placed on the European market, and that is very important for us exactly to enable innovation, and there are also very clear exceptions. Even before just the research and development phase, before that, but also for systems used also solely for scientific purposes and even for models. And then there are a number of other even special rules that actually in the AI Act aim to enable the responsible use of data and to make these systems working well and being diverse, and that's quite important indeed for the quality and the benefits that they can bring. So just an example is that in the sandboxes, for example, we have a very clear legal basis when actually further data processing of personal data is possible for certain systems. So there is a very special regime even to collect and see how in real life certain high-risk AI systems are behaving even in high-risk contexts to actually get the right data for their final stages of validation. And indeed, the quality and diversity is one of the requirements for which we try, and we also need to strike the right balance, including by the use of as relevant privacy-preserving technologies. Now, on the other aspects, as regard of how you say, do we look only at the input or more at the output? And from the AI Act perspective, obviously the GDPR continues to apply as regards, so we accept of these specific cases for the legal basis, or for example, specific legal basis to enable bias mitigation, we do not interfere. So we are very indeed happy also to have these further clarifications, how legal basis under GDPR can be further used to promote the development of these systems with legal clarity and certainty. And from the perspective of the AI Act, the high-risk systems, it is really based on the impact and then consideration. So, for example, transparency rules, and also even other cases where we look more at how actually the outputs are understandable, they are transparent, or people know also when AI is used in terms of content, or also in certain cases of high impact decisions as high risk AI systems, is where we actually complement the existing framework, but it still applies, and we think that clarity there is indeed very important for the AI development in Europe.
In fact, one of the difficult, I think, areas of how the two work together is indeed the use of sensitive data, sensitive categories that are protected, especially under GDPR, and the lack of legal basis for use of that data to combat bias and ensure fairness and ensure non-discrimination. And we keep hearing from data scientists, they need sensitive data in the system, they need to keep it, they need to retain it so they can see the model. So now the AI Act provides for that legal basis, lex specialis, on top of GDPR, but only for high risk, not for everything else. So, you know, the question is how do we, and this is where the hands of DPAs are also tied. They can't reinvent the rule, right? They can stretch interpretation, but they can't. This is maybe one where we might need some tweaks to enable this, particularly into R&D, if we consider R&D to be the AI development.
But also it goes back to the interpretation of like what would be Article 9 processing, you know, and the question is, in the context, for example, of the training of an AI model, is there actually Article 9 processing taking place? And one could argue that actually that's not the case. Yes, some data belong to the categories of Article 9, but because the purpose of the training is not to reveal any information about any individual, the purpose of the training is not to profile any individual, the purpose of the training is just to train a model, and so it could be argued that there is no Article 9 processing.
And then to add on that, so if you look at cybercrime and cybersecurity, we look at two angles of the whole chain. So we look at how do we profile criminals? Yeah, it's sensitive data, especially we look at IP addresses. Yeah, but you also want to say, oh, these are stolen credentials, these are stolen ID numbers. You want to inform the victims. So you twice aimed into a privacy discussion where you are very sensitive on how can you use the data to profile both the criminal and also figure out who are the victims and then inform the victims about the impact on their life. And I think that's and I get your R&D answer, and for me that was not the question. The problem is not that I can do R&D with more flexibly. If I commercialize that product to make it helping to fight crime, I still need to follow the rules.
Correct.
And that means that at a certain moment, everything I did in R&D, I cannot commercialize because I need to review my model and then say, oh, these data elements I cannot use, them I have to throw it away, them I have a new model. So that is kind of the challenge that you are facing and that's the reason why we don't know what we're looking for at a certain moment in time when you look at criminals, because they try to surprise you and to take an angle that companies or governments are not aware, and that's the surprise element is a big part of that. That surprise element, that's what we need to predict, and surprise comes out of real data, never out of simple data.
But these are some really reality checks. And can I sort of get everybody else's point of view on this really discussion that has started at this panel, but before as well? How can we simplify further these rules? Look how complex we get here on this panel. It's so legal, so and you know that startup SME that is trying to develop on top of the Meta, so Google's or Anthropic or ChatGPT's, OpenAI, sorry, tools, some other application. How do they go about this? I mean, they don't have privacy officers, they don't have AI responsible officers, they can't read the AI Act, they lose the will to live because they don't even understand the world, the words. So what can we do to simplify this? We heard about guidance by regulators, but is that the only thing we can do? Is it exempting them from the rules? But it's not just, remember, it's not just SMEs. Sandboxes, I'm just throwing things at.
Yeah. This is a delicate
And by the way,
topic.
don't worry, I mean, we're not going to hold you to this, right? This is for your view. It's not like,
Okay.
I will ask you that. It's your word.
Look, in my opinion, simplification is probably not enough for us to keep up with the world. What we need probably is to frankly discuss at least possible paradigm shifts in our approach to data protection, especially vis-a-vis the AI and platforms, IoT, etc. So what I mean here is, look, I mean, if you talk to investors or to people that are considering investing in Europe, if they hire a professional law firm, they will immediately warn them that the legal landscape is extremely complex. Horizontally, vertically, then you have a multi-level governance structures, some of them, coordinating on the EU level, some of them on the national level. This is indeed, if you paint the picture, if you draw the map of all these governance structures that we have built for the digital, and if you stand back and look at it, it's really a very complex network, to put it diplomatically, okay? Now, at the end of the day, it is the courts that decide about the proper implementation, and sometimes it may take even a decade to have a certain issue clarified. Now, we can produce guidelines, we can create more and more teams in charge of overseeing the rules. We can even remunerate the data protection officers better. At the same time,
That is fun. Good.
I'm not a data protection
No,
officer.
no, that's okay.
At the end of the day, the key question is how can you actually act in a way that you feel relatively safe vis-a-vis the law requirements. And of course, we can produce thousands of pages of guidelines, we can produce whatever we wish, but at the same time, the services and products built in the digital space are integrated. The companies don't just think about AI, they think about the service, the product that they want to provide, they think about the platform that they can use for collecting the data or run the AI on the platform. They think about tangible products via the Internet of Things, how this can be inbuilt and connected. So this is really getting complex. And one last remark, if I may, on the number of the regulators and supervisory authorities, etc. Jordanka and me, we were together in the negotiations on the first international treaty on AI, which was negotiated also with the non-European states at the Council of Europe. It was approved and put to signature recently, last year. I realized during the negotiations how really different the approaches to the supervisory authorities question are. Namely, when I talk to Japanese or talk to some people from elsewhere, like Mexico or wherever whatever you can think of, they say that they don't need these administrative authorities in between the companies and the courts. They don't want extra additional structures to be built as public authority structures that would be, stepping in between and requesting more time to even address the issue. And they want to have it directly handled by the courts if possible, of course. Now the key question is how you can provide enough evidence given the asymmetries, etc. So, but these are important questions. But just think about how many structures we have built in the EU, how much time does it require to actually inspect something and to arrive at a very final legal decision. I read an article recently in one of the German newspapers where they celebrated that finally after 10 or 12 years some case was finally decided about the platform content. Now with this, how can we possibly streamline and make more effective all the structures, all the people that we put into the important mission of safeguarding privacy? This is probably the questions we need to ask ourselves and have a realistic picture on how many different structures we created for the digital and how they interact.
Michael.
Yeah. Yeah, thank you very much. Because in many respects you're speaking. Michael Moran might have been better placed to answer. I mean, he has said that he's going to bring forward simplification legislation, but primarily focused on SMEs. And personally, I'm not convinced that that's enough. But only the Commission can introduce legislation. I think that discussion around what is processing, is obviously fascinating and may need clarification. It might suffice if that clarification is provided by regulators, but ultimately it'll probably be, regardless of what clarification they provide, ultimately probably be tested in the courts down the line, and then you're looking at revisiting a lot of decisions that have been made, perhaps up to over a decade, depending on which jurisdiction it comes through, how it comes through. So, I mean, simplification, I wish I could be more optimistic, because another piece of legislation that Commissioner McGrath is responsible for, but when he inherited, is the GDPR Procedures Directive, which I'm a shadow rapporteur on, and which the purpose of which is to simplify procedures, obviously. But it's really not achieving that in its current iteration, or at least many people feel it's not achieving that in its current iteration, both in the industry side, but also on the civil society side and representatives of citizens. So then, as part of that, there's a body, I think, within the Parliament, it's fair to say, who just view the whole GDPR as inadequate and needs to be reopened, and everybody is avoiding that, because if you reopen that Pandora's box, are you going to close it again? I suppose, I'm not hugely optimistic, but nevertheless, politicians tend to do what they have to do. And I think there's an increasing awareness in Europe that we have to get this right, that we're falling further and further behind our allies, competitors, choose what you want to call, the United States in particular, but also other parts of the world, that we can't get this wrong, that we do need to get this right, and it does need to be done. If that means simplification is to go further than exempting SMEs, I mean, I have hear very much what Jordanka said around SMEs, and the AIF has been very much saying that very few SMEs will be impacted by the AI Act, that a separate office will be established so that they can contact the Commission to establish exactly what their requirements are. They'll be pleasantly surprised, perhaps we are being told that they'll be pleasantly surprised with the feedback that they'll receive. But nevertheless, I mean, SMEs are sceptical because of their experience around GDPR, and maybe exempting them might not, while it's a step in the right direction, clearly it might not be enough. The difficulty, of course, is that, and it's a criticism of any regulation in this area, that, you know, legislators, this is an incredibly technical, complex area. Very few legislators understand it. I wouldn't claim to be somebody, I'm a generalist like almost every other member of the European Parliament. But there are an increasing number of legislators who want to understand it, who are willing to try to understand it, because they understand the economic consequences of getting this wrong and continuing to get this wrong are very clear and stark at the moment.
And look, I mean, we just at CIPL held last week a really interesting conversation because we published a paper together with an economics consultancy on the economic impact of personalized online advertising. Not because we want to make sure that that happens all the time, but we want to show what it means for SMEs. And we had SMEs and startups talking there, explaining that without this, they would be nowhere. They'd have to even develop the products with that early adopters group of people to whom they advertise, because they can never get the product to perfection unless they've got this group. And there was the impact of not doing that would be 80% increase in price, less people actually employed. I mean, it's unbelievable, right? And that's the economic discussions are so relevant these days. And I think we as data protection officers, you have to understand that as well when you are giving advice to your companies, right? What is the opportunity lost of not doing something? How do you actually balance all of these things? And you should be much more vocal, voicing those concerns as well. We have very little time. I want to ask actually a kind of a killer question, because this is also a question of data protection compliance. Nicola, you know, we've had some very good guidance on legal basis, on purpose as well. We said AI training can be a purpose in itself. Great, thank you, Camila and DPB. But what about the rights of individuals? I mean, you know, how do we do access requests, right to be forgotten in AI, or even explainability? We've had some court cases as well now under automated decision making, right? That's also covered in the EU AI Act. Is that good enough? And then transparency. It seems to me that's another area where the regulators are saying, you industry are not doing well enough on transparency of data use in AI. But so what should we do? How could we do this? What does good governance look like? In 5 minutes.
Yes, okay, very quickly. So the first thing I would say is that what we do is we distinguish between 3 phases for us when it comes to this type of question. The training phase, the model,
Yeah.
and the deployment.
Yeah.
So if I focus, for example, on data subject rights and focus on the deployment, there's one thing that I think we need to talk about is AI technology compatible with the way that GDPR understands data subject rights? And I think that to some extent, yes, because those rights can be exercised, but the question is how can they be exercised exactly? And I think that we've seen that some data protection authorities have been taking some interesting position on similar technology. I'm thinking, if I'm not mistaken, of the position of CNIL on blockchain, recognizing that in some situation you can implement a technical way of exercising the rights that would meet the same objective in the end. So you don't delete the model, but you just work with filters. And this is how the industry has been working on at the moment. So you object to a certain processing, or you want something to be corrected or deleted. It's going to most likely happen through a filter that will prevent the model from outputting that information going forwards. And this is, you were talking about simplification. I'm wondering whether this is something that also needs to be acknowledged in GDPR, acknowledging the fact that those rights are not completely absolute, and that depending on the technology, there might be different ways of actually obtaining the same result ultimately. So yeah, in a nutshell, that, and then of course also at training level, there's a number of mitigation that you can put in place. So, for example, the fact that you're using unstructured data sets that are not identifying individuals. So yeah, deployment and training, you can put solutions in place.
Yeah, so first of all, I'm a proud European, so I think GDPR, AI are good regulations. So we're not questioning that, we're asking some tweaking and tuning to make it better, and that's what we ask. And I think that's also the way I want to if I see, can we help in the debate for the future, kind of say, if we look at the practices and I'll start from use cases, you will probably learn a lot on how to make this uncertainty that today is around these regulations. There's a lot of uncertainty. The whole conference is based on that we don't know what to do. Yeah, that's otherwise we don't have a conference. If everyone knows what to do, we'll just do it. Yeah, so we're here all because we don't understand it, because it's too complex. So one of the things that I think what would help business and innovation in Europe will be try to limit the uncertainty of the outcome of a juridical case. Because every lawyer in every big company will be risk averse by default, and they will start with the worst case scenario. And you already have made a law in the worst case scenario with all the risks that are there with abuse of AI, and that's the starting point of the AI. Actually, let's assume abuse of AI, and then let's limit that. You should also look at the law from how do we make Europe the sound base of new AI use cases? How do we make Europe excel in innovation in AI? And how do we enable those things? It's an equally important question that should be balanced between the two.
I think Juraj wanted to comment.
Just a brief comment on what you mentioned about the certainty about the outcome of a judicial case or judicial case. What we have created under the GDPR, in a way, is a kind of decentralized constitutional justice. In other words, we expect these data protection officers and relevant people in the companies or in the government to do a kind of a weighing exercise, deciding about the conflicting interests, interpreting the values and rights that we care about. So these are extremely difficult judgments, and it's not an accident that we have created over the thousands of years institutions where we have special people dealing with this, especially in the courts, of course. So the key challenge for us, I think, is a certain degree of realism. If we are to create a certainty or predictability, can we realistically expect that all these people will match those expectations of the judges that then will do the weighing exercise or balancing exercise, proportionality test, etc. Is it realistic that we can expect in such a complex environment that AI brings with all the volumes, speeds, veracity, etc., etc. Can we actually expect this, that people can do this in such a decentralized way and then rely on it? This is a key question that I see there.
If I can, just on that point, I think that's why the Act and its objective is very clear with the tools. It actually aims to provide for the clarity and with the standards that we are in process of developing and that will provide presumption of conformity, or with the code of practice on general purpose AI. Indeed, there are lengthy discussions and a lot of many thousand stakeholders being involved in those processes precisely to nail down and balance the different considerations, make these tools practical, but this will be a very essential way for companies to rely. And also the sandboxes, the help desks with further opportunities, and then really having safe space for dialogues with the competent authorities, for clarifying all these difficult issues that we do have indeed, because it's also technology that is now evolving. Things are also emerging, including like risks are emerging, and our objective is to keep also the legislation future-proof, to identify both the hurdles and the barriers, but also the enablers in this system. So I think that's why, for us at least in the office, it's really essential to work on all these tools and make them for the use of SMEs and all companies.
And thank you for that. And by the way, we at CIPL have got a whole project on EU AI implementation and trying forever to get the AI office. They always tell us, we are so busy to come to your meetings. So now you have said it, you have to come. No, excuse me, I'm joking. But no, this was a really interesting conversation. And I think there is a, look, you know, it's not easy this, right? And we're going to get this right. Certainly, the role of people in this audience here is huge, right? As data protection officers, you're not here just to protect privacy, you're here to enable responsible use of data. I think you have to understand that. And I think regulators have to behave in that way as well. So you do have a difficult job. I'm not sure that we can actually provide a provision. I believe companies need to be accountable, and you have to do your homework. And I think that's what the AI Act expects you to do, your risk management system, conformity, the tools, the rules, etc. I think we also have risk-based approach in both laws, and we have forgotten that a little bit in GDPR. The guidance, excuse me, DPS has been very flat, like everything is risky. Well, no, it's not. And only the things that create real risks and harms, I think that's where we should be focusing. And that's your job as data protection officers, to do better. But we do need a consensus, Juraj, to your point, on what we all agree is a risk, right? Because I think at the moment, we don't have that agreement in industry, with regulators, and with courts at all. I think there is more we can do with innovative approaches like innovation hubs. UK is doing that, sandboxes, but sandboxes are not compliance tools. They're really experimentation. So we need to allow this to happen, sometimes with stretching the rules as much as possible. Otherwise, people will not want to go through another conformity assessment. And then the last point, you're going to laugh, but actually I'm now going to be going to another event moderating Kilian Gross on standards in AI and how we can actually build from the standards in EU, in UK, from the ISO, even NIST in the US. Why not? So there is a lot that we could do maybe through that, because these are more flexible tools that give the certainty but don't have quite the rigidity of oil tankers that our laws are. And so with all of that, finally, yes, look at the UK. UK is doing some very interesting things, and I think we remain adequate despite the tweakments of GDPR through their bill. So, there could be, again, some interesting test cases to see how UK takes lead, perhaps, in some of these things. So with that, I think we've come up. It says wrap up, please. And I think I have to go as well. Everybody here has to leave. Thank you very much. Great panel, great conversation. I hope we've done more than scratched the surface, and we've given you some optimism, but it's not easy, but that's everybody's job to do this together. So thank you very much, everybody.